we received a contact from a law firm regarding the case of a woman residing in Korea. This is to emphasize how crucial trust is, no matter how much we stress it. So, I am going to explain in detail how painful the probate process can be and why I have emphasized the importance of creating a trust. Before we get started, this channel provides professional information on U.S. law, tax law, and financial planning in an easy-to-understand manner. Not just this video, we will continue to upload more beneficial content in the future. So, make sure you don't miss out. To do that, if you haven't clicked yet, please make sure to click subscribe and like now. Then let's get started. What is a trust? Before we dive into specific examples, let me briefly explain trust probate again. A trust is the owner of assets. It's called a grantor, a reliable person or institution. The trustee is the trust. It's a legal arrangement where assets are transferred to be managed for the benefit of specific beneficiaries. It's not too far off to think of it as a company. Simply put, you can think of it as a kind of container for managing assets. When you place your assets in this container legally, they become the property of this container, the trust. This means that even if the owner passes away, the assets can be transferred to the next beneficiary without court approval. On the other hand, probate is, simply put, a legal process involving the court to transfer the deceased's assets to the heirs or beneficiaries, requiring court approval. So, I will explain how significant this difference can be through a case we handled. What it was about was this. Winter of 2020. We work with several major Korean law firms, and it was probably a firm like Kim and Chong. We received a contact from a law firm about a case involving a woman residing in Korea. So her husband, he was a businessman involved in global business. He had also invested in assets like real estate and financial assets in the United States. His wife, let's call her Ms. A. The wife was residing in Korea. She was a homemaker with 2 children. Now, let's call the husband Mr. B. He suddenly passed away from a heart attack. So, they needed to sort out the assets in the United States, but they didn't know how to go about it. From the first call, I thought this wouldn't be easy or that it would be a very long and painful process. Specifically, the situation was like this. Her husband, Mr. B, the assets he left in the United States, they were valued about $6.5 million in total. Specifically, looking at it, there was a house in Irvine, California, valued at about $2 million. And there was about $300,000 in a joint bank account held by the couple. And personally, there was about $2 million in Mr. B's personal bank account. Additionally, there was about $2.2 million in a personal brokerage account. So when I looked at the details, the reason I thought it was quite bleak was because all the assets, except for the $300,000 in the joint bank account, were subject to probate. They didn't create a trust. So process had to begin. They had to open probate. First, you need to check if there's a will, and fortunately, there was a will. It stated that all the assets would be inherited by the spouse, Mr. A, in case of any unfortunate events. But this was just the beginning, as they had to file a petition with the California Probate Court. Then they prepared the death certificate, the original will, the heir statement, various notifications to creditors, and several other documents. Especially, as I mentioned earlier, Mr. A, the spouse, was a housewife living in Korea. So, because it's Korea, all documents needed notarization, translation, and apostille procedures. An apostille refers to the procedure that allows Korean documents to be notarized and accepted by the U.S. court. These procedures were necessary. This process alone took several weeks. Then the petition was filed with the court. A probate hearing was held. So, a notice of the commencement of probate was sent to all financial institutions. From that point, all of BC's accounts were frozen. The same applied to real estate until the court's final judgment. No transactions could be made. So, what specific inconveniences and crises were there? The first one is, the issue was that we had to pay inheritance tax, but the account was frozen. This happened quite quickly, but why? The payment deadline is essentially the following year. After the person passes away, when you have to file the inheritance tax and pay it at the same time to the IRS. But the problem was that we needed to pay the tax, but we couldn't withdraw the money because everything was frozen at that time. So, from Mr. A's perspective, he tried to liquidate his assets in Korea, but liquidating suddenly and unexpectedly means a significant loss. So, we decided not to do that. We filed an emergency petition. We asked the probate court to release the amount equivalent to the estate tax from the deceased's bank account, which had $2 million, to $2.2 million. So, we submitted the petition. through the probate attorney. It took a lot of time, and we had to provide explanations several times, going back and forth. Finally, after waiting, we barely received permission to unfreeze the account, but only for that specific amount. Since we barely met the deadline, no interest or anything like that accrued, but we still had to bear various costs like energy and attorney fees. For your information, regarding inheritance tax between Korea and the United States. Moreover, Mr. B was a Korean national, a Korean person, living in Korea. Therefore, from Mr. A's perspective, who inherited Mr. B's assets, he had to report and pay inheritance tax, not only in the United States, but also in Korea. Theoretically, Korea has a foreign tax credit system, so for the inheritance tax paid in the US on assets located there, the amount of inheritance tax in Korea could be reduced. However, in practice, the process did not proceed as easily as it might sound in theory. There is a deadline for applying for the foreign tax credit, and there is no guarantee that the documents required by the National Tax Service will be sufficiently covered by IRS documents. As a result, there were situations where you had to go back and forth, racing against time to complete these procedures. So, in cases of international inheritance, you also have to consider the additional burden of dealing with the tax authorities of each country. So, although this was just a reference, even in the case of inheritance tax between Korea and the United States, theoretically, there are people who say things like this. When you directly own property in the United States, even if you pay inheritance tax there, some might say that since you will anyway bear the inheritance tax in Korea, you can get a foreign tax credit for what you paid in the US, so there shouldn't be a problem. That is incorrect. Why? Theoretically, it's correct, but in practice, when you deal with it, there are a lot of hassles, uncertainties, and variables. It's a burdensome process, so people don't want to do it. Therefore, if you had done a little planning earlier, you could have made those assets not subject to inheritance tax in the US at all. But because that preparation wasn't done, these additional cumbersome processes were compounded. Of course, this is about the inheritance tax issue. It's somewhat independent of today's topic, which is probate. I won't discuss it further. There is a separate video on how to avoid US inheritance tax on US investment assets. There's a thumbnail now. It will be content worth referring to. So secondly, what happened was COVID. It was during the COVID period. I received the notification of this person's passing at the end of 2020. At that time, as you probably all know, there were quarantines and such due to COVID. So due to various requests from the court and meetings with lawyers, there were situations where Mr. A had no choice but to come from Korea to the United States. He came about 3 or 4 times. So he had to deal with quarantine and various daily matters in Korea, and there was the inconvenience of having to come because of this. It wasn't that he had to stay in the US for a long time just to sign documents and handle various matters, but there were these inconveniences, and of course he had to quarantine. The costs of quarantine and the impact on his business and daily affairs were not insignificant. And then there was a third issue. Since his assets were frozen, he couldn't sell his real estate. He also couldn't trade stocks. Mr. A had to pay inheritance tax in Korea as well. So it wasn't just about the assets in the US. Mr. A had to pay inheritance tax because his husband, Mr. B, also had many assets in Korea. Originally, he planned to sell US real estate to cover this, but as mentioned earlier, he couldn't sell real estate during the probate period. As a result, Mr. A ended up spending time getting a loan in Korea to pay the inheritance tax. Naturally, she had to bear the burden of the interest as well. The same goes for stocks. There were assets worth over $2 million in the stock brokerage account, but they couldn't be sold, leading to a situation where the desired transactions couldn't be made. It was very burdensome and a very unfortunate situation. Then fourthly, is called an executor. Selecting an executor to carry out the inheritance was also an issue. There was no one we knew locally in the United States either. Also, since the Korean relatives did not have the right to stay in the United States, they couldn't become executors. So we appointed a local lawyer as the executor, but of course this meant we had to bear additional costs and such. Besides that, there were many other administrative difficulties. All court documents, including those from the probate court, were naturally in English. As a result, just the translation costs alone exceeded several $1,000s. And then there's the time difference between Korea and the United States. So Mr. A sometimes had to go back and forth, day and night, as I mentioned earlier. Communicating with the probate attorney or other representatives in the United States, we had to do the same. Also, with the American financial institutions, they do not recognize any notarized documents from Korea. Each time, we had to request local notarization and also get notarization from the embassy. And also, I still remember that there were several banks that had situations where they had to struggle with a specific account for months on end because they didn't have a dedicated department to handle the accounts of deceased people. What happened in the end was, as I briefly mentioned earlier, it was concluded last August. It took almost 4 years. The court finally made a ruling, and it was concluded. However, during this process, the costs incurred by Mr. A's when calculated at the time, amounted to more than 3% of the asset size, not just the probate. There were additional costs related to inheritance tax processing, emergency loan interest in Korea, translation and interpretation fees, travel expenses to the US, quarantine costs, and various other expenses, not to mention the time involved. The emotional toll from such uncertainties and things like that are also worth mentioning. What's important? The point is that these painful processes could have been avoided. What is it? If Mr. B had created a trust during his lifetime, what would have happened? First, the probate process itself would not have been necessary. Right? What additional benefits would come from that? Second, Ms. would have been able to access the assets immediately after her husband's passing. And of course, she could have paid the inheritance tax on time. And third, if necessary, she could have sold real estate or stocks without any issues, right? And during that 4-year period, we talked about probate costs and various other incidental expenses. Not just financial costs, but also saving time, emotional strain, and various uncertainties. And I also added that with proper tax planning, it could have been possible to avoid paying estate taxes in the United States. So then what was a living trust or a trust? If you had created one, probably would have cost just a few $1,000s. So, considering the financial cost, emotional cost, hassle, and uncertainty, what would be 1% of that? The actual cost would have been less than 1%. That's why the importance of a trust cannot be overstated, especially in this case as it involved a foreign investor. The spouse, who had to deal with multiple heirs in Korea, inevitably faced a situation where this issue seemed more complicated and serious. So, in reality, Mr. I said something like this. He mentioned that although it's something to talk about, after everything is over, he never thought he would have to go through this, and of course he would have set up a trust. But that's hindsight. Aside from the money during this probate process, the stress and waste of time were really difficult. So naturally, people would want to avoid going through such situations, and for that, a trust is necessary. It's not just about saving costs. It's about preparing to reduce the stress burden on the loved ones left behind after death, especially for those living abroad in countries like Korea, dealing with time differences, distance, and unfamiliar U.S. legal processes, such as appointing an agent. These difficulties can multiply several times over. So, in conclusion, first, regardless of the size of your assets, if you own assets like real estate in the United States, you must consider a trust. That's number one. Number two, especially if you reside in Korea, setting up a trust for properties invested in the US is not an option. It's a necessity. Thirdly, of course, you might think this way. I'm not worried about inheritance. If an inheritance event doesn't occur, then you don't need to do it. Of course, paradise would. You might think such things won't happen, and they probably won't, but nevertheless, it's obviously necessary to consider the possibilities of such situations and prepare for them. In the previous example as well, this person was very actively involved in business, but then he suddenly passed away from a heart attack. So, it's necessary to take such aspects into consideration. Fourthly, the most important thing, let's think about the cost versus the benefit. In that case, it would be an investment. That doesn't even need comparison. That's what I'm saying. So today, through real-life examples and our own experiences, we discussed how probate is such a painful process and how these processes could have been avoided through a trust. That's all. I hope today's content was helpful. There must be many people around you who need this kind of information. This channel is a space that grows with you. Don't miss out on essential information next time by subscribing and liking. Please help ensure it is well conveyed to those around you. Thank you.